Hello, Cybersecurity National Security Law class. Welcome to Class 5. And in this class, we're going to start talking about internet surveillance. And obviously, this is a very hot topic. It's been in the news, and it's something that continues to be debated. And in many ways, I think it's really the heart of what we're talking about in this module. What I first want to do is point out to you the range of existing legal authorities for gathering electronic information. And this chart puts a number of these together. I didn't ask you to read all of these statutes just because we don't really have enough time to read through all of them. But the chart here summarizes these different authorities. So the basic principle, of course, is the constitutional principle that personal information need not be disclosed to the government without some reason, and in particular in the criminal context without some kind of showing of probable cause. So the first list on this chart is the wiretap statute. So when you think of a wiretap, you probably think of the kind of classic old gangster movies where the feds are literally tapping into the phone line, and indeed that is where the notion of a wiretap comes from. And the statute originally is created to deal with that, but the statute is much broader than just that. So essentially when you think of a wiretap, you want to think of the contents of communications in transit. So real-time in-transit contents. And essentially what the wiretap statute requires really goes beyond the minimal requirements of the Constitution and requires something that you might consider a super warrant. That is, it requires a showing of probable cause, which is what the Constitution requires, and that normal investigative procedures have failed or will likely fail or are too dangerous. So there's some recognition in the wiretap statute by Congress that intercepting communications in transit is even more serious than other kinds of intrusions on privacy that would require an ordinary warrant. Then we have the Electronic Communications Privacy Act, and what the ECPA does is set out procedures for the government to obtain either information that is in storage, electronic storage, or information that is simply identity and billing records. And the ECPA divides up the content of communications from what we might consider header information, which is information about the transit or identity of who is receiving certain communications. So if you notice here, if the information is in storage 180 days or less, the government is required to get a warrant showing probable cause. If the information is in storage longer, more than 180 days, the government is required either to obtain a warrant showing probable cause or a court order with advance notice to the subscriber, in other words, to the person whose information it is, showing why the information supposedly is required. Now, why the difference there? Well, if you're giving notice to the subscriber, then the subscriber can contest that. Very similar to, for example, a subpoena in a civil action. You certainly can subpoena the contents of records in a civil action from a third party, but the person whose information it is would have an opportunity to move to quash the subpoena. And so a warrant, of course, is an ex parte application. There's ordinarily no opportunity to contest the warrant. You only can later on contest the introduction of that evidence if you believe the warrant was improperly issued. The pen register and trap and trace statute relates to obtaining non-content routing information in real time. So the ECPA is information that is in storage. Wiretap, the contents of information in real time. Pen register, trap and trace is non-content routing information in real time. And again, think of the old gangster movies with the feds kind of tapping into the wire. You could actually put a physical device on a phone, and that physical device could trace all of the phone numbers that were dialed out of or received into that telephone. That's pen, register, and trap and trace, and now we kind of transpose that into our current electronic world. So notice that for the pen, register, trap, and trace, you don't require a warrant, you only require a court order, and you have to make a showing that is something less than probable cause. In other words, that the information is likely to be relevant to an ongoing investigation. Notice also under the ECPA, you can obtain simply subscriber information. That is, who's the identity of a subscriber and what is their associated username, with a court order on a showing much less than a warrant that it's relevant and material to an ongoing investigation. There does not, in that instance, have to be notice to the subscriber. So moving down this list, we have NSLs, or National Security Letters. This is a specific federal statute that allows the FBI to obtain subscriber information and toll and billing records. And toll and billing, that sounds like telephone, that's right. But again, this also applies in the electronic age to electronic communications. And again, all it requires is for the FBI, they don't even need to obtain a court order, they simply need to issue the letter on a statement that the information is relevant to an ongoing investigation to protect against terrorism or clandestine intelligence activities. There does not need to be any disclosure to the subscriber, but there is an opportunity for the holder of the information, say an internet service provider, to challenge the letter. These letters, along with the expanded FISA procedures under the Patriot Act, became quite controversial after 9/11. And then we get into the FISA statute, the Foreign Intelligence Surveillance Act. And we'll talk in some depth. You can see here in the slide the kind of summary of those provisions, but we're going to talk in just a moment in some depth about what those provisions are. Before we specifically talk about the FISA statute, let's talk a little bit about some history and some constitutional law about the federal government's ability to use surveillance techniques in the context of national security involving U.S. citizens under the Fourth Amendment. And this is the U.S. District Court, Eastern District of Maryland case that I gave you. The caption of this case is a little bit weird. It's set up this way because it was a petition for mandamus that went up on appeal and then went up to the Supreme Court. So as you read this case, you can see a little bit of the background. The case involves this guy, Lawrence Pun Plamondon, and you can see on the slide here a relatively recent, within the past 10 years or so, picture of him. He was a lot younger, obviously, when all these events happened, but he was a kind of well-known radical activist hippie in the 1960s. He was a founder of an organization called the White Panthers, which was a organization that was supporting the goals and aims of the Black Panthers in the 1960s, which of course was a radical African-American organization that at times even advocated the use of violence to deal with kind of the racial tensions at the time. Plamondon was allegedly involved in the bombing of a CIA recruitment office in Michigan, and I gave you a link to some of the background materials. Nobody was injured or killed in that bombing, but the office was damaged, some records were destroyed, and so on. Well, the government had information about Plamondon's alleged involvement because it had wiretapped his phone conversations, and it was phone conversations between he and members of the Black Panthers, and the government had done that wiretap without a warrant, so had done it without going under any wiretap statute or any other warrant requirement. And the government's argument was that the Black Panthers and the White Panthers and all of these radical activists at the time were presenting a national security threat, and in fact were threatening the stability and safety overall of the U.S. government, and that therefore the president had the authority under his inherent executive powers to engage in this surveillance activity without having to go to the judicial branch for a warrant. Incidentally, Plamondon was the first hippie on the FBI's 10 most wanted list. He became a fugitive after that CIA bombing and after he had been charged with this offense before this case eventually got litigated up to the Supreme Court. To me, this is a really fascinating case. It illustrates, I think, once again, that nothing really is new. Most of you didn't live through the 60s. I didn't. I was just an infant during the 60s, but kind of having a little bit of a sense of that history, the late 60s, mid 60s, early 70s. And we know it, of course, as the time of Woodstock and all of that sort of thing. We tend to think of the hippie culture, the counterculture of that time today in sort of heroic or nostalgic terms. But there certainly were elements of that culture in that time that were considered highly suspect. There were at least some extreme elements of that culture, I think fair to say, a very small minority who did advocate violence and so on. But there was an enormous culture clash over whether these people were subversive of the government and over the kind of scope and extent of the ability of the federal government to conduct surveillance activities on them, which they did to a very extensive degree. So this case eventually finds its way up to the Supreme Court, and you can frame the issue as whether there is judicial approval required for national security surveillance. And I should really have added to this slide national security surveillance that involves the surveillance of U.S. citizens. Because, of course, if it's simply a surveillance of foreign citizens, the foreign citizens don't have the same rights as U.S. citizens under our Constitution, and there's a different set of rules that would apply, really international law rules. So we're talking about surveillance that involves U.S. citizens. So the U.S. Supreme Court, first of all, it looks at the wiretap statute as it existed at the time. And the wiretap statute has some specific language that indicates that the statute does not limit the president's ability to do what the president needs to do and is able to do under the president's inherent national security or war powers. So the government's argument is that the president has this inherent power and that the statute carves out this inherent power. And ultimately, as you see from reading the opinion, the court disagrees. And what the Supreme Court says is, well, all the statute is doing here, it's kind of like a savings clause. It's just saying the president's powers are the president's powers. But what we're doing here is specifying certain conditions under which the government can surveil American citizens. The portions of the statute that deal with surveillance require a court order. It is true that the court recognizes it is true that the president has the fundamental duty to preserve and protect the United States, and that it's really a kind of core question of the executive's function to protect the people against subversion and war. And indeed that it may be necessary for the federal government to use surveillance in order to protect the national security. And in fact, the Supreme Court says there's nothing astonishing about this. We're not surprised that the government uses surveillance in the exercise of this power. And in fact, such surveillance has been used and sanctioned specifically by U.S. presidents and attorneys general since World War II, really. So that's not surprising. And the court further notes that, and remember, this is 1972, events that are occurring in the 1960s, and already the court is talking about the complexity of these activities, the ability of conspirators to use electronic means like the telephone networks to carry out their plans, and so therefore there can't be a blanket rule against surveillance of the telephones. But the court says, recognizing all that, there has to be a balance with the requirements of the Bill of Rights. There's always this tension. The court doesn't use exactly these words, but the thread underneath this, there's always this tension between liberty and security. And so we've got to figure out how to balance those things in this context. And the court notes these cases that involve questions of national security very often are going to impact on core First Amendment values, because the government is often going to suggest that people who are speaking against it are subversive, and that as people speak against the government, they threaten the government, and that therefore national security would require the government to surveil them and perhaps in some way to limit or shut down their activities. And this is a problem. This is one of the things the First Amendment is originally designed to safeguard, the ability to criticize the government. And we can't allow the legitimate need for security and the legitimate need for certain kinds of surveillance to put a chilling effect on vigorous debate, vigorous discussion. All of these are, of course, very familiar First Amendment values and very familiar kinds of things that we have to balance in this sort of context. So the court says, kind of the judgment of history, the weight of history under the Fourth Amendment is that if the executive is able to carry out this kind of surveillance without the check from the judicial branch, that's going to be a problem. That in fact this goes to kind of a core aspect of the design of the separation of powers under the Constitution. There has to be some kind of judicial check on these activities, and the court notes that this involves some kind of prior judicial determination, some kind of judicial examination of this activity ordinarily before it occurs. The court says we can't accept, notice the government's making this argument that, look, this is really subtle, this is really complex, it moves fast, there's a high need for secrecy, and the court says, yes, all that may be true, but these are the kinds of things that courts are involved in all the time. Now, notice this final bullet here, this little quote. The case only involves, the Supreme Court said, the domestic parts of national security. It's not addressing dealings with foreign powers or their agents. We have to make that distinction constitutionally, and we have to make that distinction pragmatically. The courts are well qualified and well experienced in judging whether a U.S. citizen's constitutional rights are being unduly impacted by some kind of surveillance or evidence gathering activity. The courts are not necessarily qualified to judge the decisions made by the executive with respect to foreign powers. That's traditionally left to the executive, or a substantial amount of discretion is left to the executive in the conduct of foreign affairs. So in this particular case, the majority says that in fact the executive would have to go to the court and get an order or a warrant under appropriate procedures. Now notice this concurrence by Justice Douglas. So Justice Douglas writes separately to indicate that he agrees with the majority's reasoning, but he wants to emphasize how serious he thinks this issue is. And again, this is kind of in the category of saying nothing is really new, right? Justice Douglas says, federal agents want to rummage for months on end through every conversation, no matter how intimate or personal, carried over selected telephone lines. And we can kind of see the echo of that in our thinking about electronic surveillance today. So this is a little bit of constitutional framework or background about the scope of surveillance powers and the constitutional requirement of some kind of judicial authorization under the Fourth Amendment. I also gave you Executive Order 12333. This executive order is quite famous and important in the intelligence community for a number of reasons. So remember that an executive order is an order issued by the president. It is designed primarily or the notion behind it primarily is that it's supposed to sort of be administrative and kind of the internal workings and administrative policies of the executive branch. But as you might know from kind of contemporary debates, the use of executive orders has really expanded, particularly since the George W. Bush administration, and of course the Obama administration's use of executive orders in a number of areas, including in cybersecurity, has been, a topic of hot sort of political debate. This particular executive order goes back to President Reagan and kind of the height of the Cold War. So what this executive order does is it tries to clarify and consolidate the roles of the United States intelligence services, and it establishes the National Security Agency, the NSA. And notice that the remit of the NSA is for the unified and effective organization of signals intelligence. What is signals intelligence? Well, kind of think back to the old days of sail, of shipping, and so on, where you would actually have flags that you would signal to the other ships. You would do that on battlefields as well. You might use lanterns and so on, and then that, of course, all became electronic. So signals intelligence is the term for any kind of electronic eavesdropping, surveillance, that sort of thing. So the NSA is the body that, according to this executive order, is responsible for that. So notice that this executive order in Part 2.3 sets out some policies for how the federal government, for how the executive branch, the NSA, can collect information, signals intelligence, involving U.S. citizens. So the kinds of things, and there's a long list of things, I've just pulled out a few to highlight for you. So information that's publicly available, that's always going to be really not subject to any protection. Notice there's some broad categories of information that could constitute foreign intelligence or counterintelligence information, information obtained in lawful foreign intelligence or counterintelligence, information needed to protect the public safety, information acquired by overhead reconnaissance. All of these kinds of things are really covering two broad areas. One is information that's otherwise public or otherwise gathered from general reconnaissance that isn't targeting U.S. citizens, or information that is otherwise lawfully acquired in the course of ordinary kind of surveillance, signals intelligence activity. Effectively, it's setting a broad policy, again, back in the 1980s, that to the extent the law allows it, and to the extent it's needed for national security purposes, the NSA will be collecting this kind of information. Now, I just wanted to point out two other provisions of this executive order. They're really not directly relevant to our class involving cybersecurity. They are directly relevant to the use of drones during the current war on terror. So I just want to point it out. Some of it's been in the news, but it's also just a fascinating kind of reflection of history. So this relates to human experimentation and assassination. So notice that human experimentation is not allowed without informed consent, which means, of course, it is allowed with informed consent. And to some extent, I think you would see that needs to be so. I mean, there might be experimental weapons systems or other things like that. What's the historical background to this? Part of it, you may know, is the experiments using LSD on military personnel and other people without really their full knowledge, to see the effectiveness of that as a battlefield weapon. Secondly, there is a prohibition on assassination. What's the historical background of that? As we've discussed a few times in class, the CIA, in fact, was involved in assassination attempts and assassinations during the course of the Cold War and the Vietnam War. That provision is the one that's really in significant debate concerning the use of drones. Is the use of drones targeted drone strikes, an assassination, or is that consistent with the international law of war, the targeting of enemy combatants on the field of war? That's a big debate. Okay, so let's talk a little bit now about the FISA statute. So some of the background of the FISA statute, I think, is really fascinating, and it's interesting to see how it's developed. So as we just mentioned, and as kind of reflected in Executive Order 12333, there is this history of the U.S. intelligence services under the direction of the president, or sometimes without really the president's direct knowledge, kind of running amok, and particularly during the Cold War and particularly during the Vietnam War, going off and doing things that were of dubious legality, including assassinations. This led to some congressional investigations and a report called the Church Committee Report. You can look that up if you're interested in it, that details some of these things. This led to kind of a debate in Congress about, well, what is the role of the intelligence services? Where do they fall? Are they simply under the control of the executive, or should there be some more specific congressional oversight, and what should the role of the judiciary be? And that gives rise to the FISA statute. And so originally what the FISA statute is designed to do is to say, when the executive is authorizing foreign intelligence surveillance, that there needs to be some kind of procedure where the executive branch goes, at least in some cases, gets a court order, other cases doesn't have to get a court order, and there's at least a record of that. And so it was relatively uncontroversial prior to 9/11 and the amendments in the Patriot Act and the much more extensive use that was made of it after 9/11. It was certainly used, and it was regularly used for foreign intelligence surveillance, of course, through the end of the Cold War, but it's really the war on terror that changes the dynamic. Why does the war on terror change the dynamic? Well, I give you an excerpt from the 9/11 Commission report, and as you look at that, you can see some of the findings in that report. It's, of course, I think, useful and chilling for us to go back and look at that and remember where we were on 9/11 and just after 9/11. But one of the main criticisms and findings of the 9/11 Commission report was that various pieces of the federal government knew about some of the aspects of Al-Qaeda's plot to attack the World Trade Center. Even if not in detail, at least knew enough about it that if someone had been able to put these pieces together, the government may have known and may have been able to foil the plot. And in particular, the FBI had some pieces of information that it couldn't or wouldn't make available to other branches of the government, because the main role of the FBI was investigating criminal activities, while you had the CIA doing foreign surveillance and investigations and covert activities, and you had the NSA collecting signals activity. And because of some of the concerns about the legal requirements, there were policies put in place to keep some information from flowing. So one of the main concerns of the 9/11 Commission, which was a very highly regarded bipartisan commission, was that these walls, these intelligence walls, needed to be broken down. One of the ways that happened was through the Patriot Act, and one of the things that the Patriot Act did was to expand the ability of the federal government to acquire and use information that even involved U.S. citizens, or that encompassed U.S. citizens. Why the concern about U.S. citizens? I mean, why not just say, look, this is Al-Qaeda, these are all foreign nationals, we really don't have these concerns. Part of the problem was that the Al-Qaeda cells were sleeper cells in the United States, and they did involve communications with and activities with people who were U.S. citizens. So it wasn't really the case anymore that you have a foreign nation state and foreign agents who are relatively easy to identify. You have now foreign nationals who are acting not necessarily on behalf of a nation state, but on behalf of a loose agglomeration like Al-Qaeda, who are working with people who also are U.S. nationals, some within and some outside the United States. So how do you do that kind of activity without tipping them off, getting the right information, but also regarding the constitutional rights of those who are U.S. citizens? That makes it really difficult, and that's part of what the changes to the FISA statute were designed to do. We should also note here, and we'll talk a little bit more about this in the materials for next week, but in addition to procedures under the FISA statute, the George W. Bush administration began a wiretap program outside even of the FISA statute. So as we'll see, the FISA statute as amended by the Patriot Act doesn't really require a warrant. It does require a court order, but it's a relatively low showing. It doesn't require a warrant on the same kind of probable cause that we expect for a crime. But even outside of that, the Bush administration was going ahead and doing collecting internet information, emails, and so on without any kind of court order, and asserted as authority for that the inherent presidential authority in time of emergency or war. That was even more controversial. I would say even more controversial. It was also very controversial, and we'll talk about that a bit more next week. What we're going to focus on this week is the surveillance under the FISA statute. So the FISA statute has been on the books. Obviously, the Patriot Act amended it. All of that, of course, is public record, is public knowledge. What wasn't public record and wasn't public knowledge was either the warrantless program and the non-court order program the Bush administration had enacted, or the scope of the metadata collection that was in fact authorized by the FISA court. We only learned about those activities through the documents disclosed by Edward Snowden. So in class we can talk a little bit about what we think about Edward Snowden. Obviously his disclosure of those documents violated a ream of federal laws, and there are people who consider him a traitor, and there are others who consider him a patriot, and we can kind of debate that in class. We knew that there was some of this kind of activity going on, but nobody knew the extent of it until these disclosures came to light. And of course we knew what the statute said. So what does the FISA statute say? It does establish a special court, the FISA court. The FISA court is made up of sitting federal district judges selected from various districts with a certain amount of expertise. So it's sort of a specially designated court of sitting federal judges that periodically meets. There is also a FISA court of review that is appointed from federal district and circuit judges that has the ability to review the decisions of the FISA court. Now the trick with the FISA court is that most of its proceedings are classified. So it is therefore a court that operates in secrecy. And that, as a lawyer, that ought to raise some alarm bells and some red flags. Now, it is not necessarily the case that courts never operate in secrecy. There are circumstances when courts do operate in secrecy. Even in civil cases, I've been in civil cases where there have been protective orders. In fact, it's pretty routine in intellectual property litigation, which I did a lot of, to get a protective order that seals at least part of the record. I can only recall one occasion in my sort of practice life when literally the federal marshals sealed the courtroom doors because of a protective order and some testimony that was happening. But it does happen sometimes. But there has to be a specific showing for that to happen. For an entire court, for most of its proceedings to be classified, is pretty extraordinary. Now, I do have a friend who used to head the cyber division for the FBI here in Newark. He's now a private consultant. And he's the only person I know personally who ever testified before the FISA court. And he did that when he was an FBI agent. And, what he tells me is that the procedures were very rigorous, that the court asked a lot of questions, that the government really had to go in with a very strong case before it was able to justify all this. And that very well may be true. Nevertheless, it does raise a concern about the fact that it's not truly an adversarial process and that it is done in secret. So what can the government get under the FISA statute? There is foreign intelligence information that the government can get without any kind of court order at all. So there can be electronic surveillance for up to a year if it is solely directed at communications between or among foreign powers, or acquisition of certain kinds of technical intelligence. And there's no substantial likelihood that the surveillance will acquire any contents of communication involving a U.S. person. So that's there, and that's part of kind of the difference between sort of foreign affairs and domestic surveillance. But of course, as we mentioned, a lot of the kind of activity that the government was concerned about after 9/11 was communications that were, in one way or another, involving U.S. persons who may be connected with terrorist cells involving foreign persons. So in that case, it would be necessary to obtain a court order. So what would the court order involve? So if the surveillance is likely to involve communications of a U.S. person, a federal officer must make a certification to the FISA court, and the certification must be approved by the Attorney General. Why does it have to be approved by the Attorney General? It escalates this issue and requires the very highest level of approval. This is supposed to limit the circumstances under which some federal agent might decide that they want to do this. The certification has to certify that the ultimate target of the surveillance is a foreign power or an agent of a foreign power. Minimization procedures have to be adopted. We'll talk in a moment about what that means. And the certification has to certify that a significant purpose of the surveillance is to obtain foreign intelligence information. Now, this is an important change that the Patriot Act made. Previously, the certification had to state that the primary purpose of the surveillance was to obtain foreign intelligence information. The statute was changed to say that it's a significant purpose. So, what's the difference? Primary purpose, significant purpose. We can see the difference in that language, and as lawyers we know that can make all the difference in the world. So a significant purpose is really broad, and you can scoop in a lot of things under significant purpose that perhaps you couldn't get under a primary purpose test. The certification also has to state that the information can't reasonably be obtained by normal investigative techniques. Now again, this does put a little bit more burden on the government, but the showing here is probably relatively minimal when you think about what normal investigative techniques might involve in these kind of circumstances. So the certification is filed with the court, with the FISA court, and then the FISA court then has to determine whether there's probable cause to issue an order approving the requested surveillance. So what is the probable cause? Now, remember, the normal probable cause under the Fourth Amendment for obtaining a search warrant is probable cause that a crime has been committed, or is being committed, or is about to be committed. Right? So you've got to make a showing that there's probable cause that there's a crime, and that requires you to specify, to some degree at least, what the crime is. Here, that's not the showing of probable cause. The probable cause showing is simply that the target of the surveillance is a foreign power or an agent of foreign power, and any of the facilities that are being surveilled are being used or about to be used by a foreign power or an agent of a foreign power. This is a really low threshold of probable cause. All the court needs to do in looking at the certification, remember, it's a certification submitted by the government. It's not an adversarial proceeding. Now, of course, the government officer approved by the Attorney General has to certify this under oath, potentially, theoretically being liable for perjury if it's not true. But nevertheless, all it has to show for probable cause is that it's targeted at some foreign power or agent of a foreign power. So if ultimately the purpose is to find communications between Al-Qaeda, or today also we might say ISIS, this is not a hard showing at all to make. The court also has to find that the minimization procedures are satisfactory under the statute, and the order issued by the court has to have some specific expiration dates. It can't be totally open-ended, and you can see in this bullets here what the expiration dates included. The Attorney General can act without even obtaining a court order, even if it's going to involve U.S. persons under emergency circumstances. And when that happens, the Attorney General has to go back after within 7 days and go ahead and obtain the order. Again, we'll talk a little bit more about that in the materials for next week when we talk about emergency powers. But just note right now that under the FISA Act, and this is a common theme, the executive is allowed to take certain actions that it wouldn't otherwise be allowed to take without judicial approval in the event of an emergency. So what are minimization procedures? And this is a really important aspect of the FISA statute, and a lot of the cases, and there are a number of cases that we could have read that I didn't give you to read just because it's too much volume for this module, about what minimization procedures are. You will see statistics quoted, and I've put them out there myself, that something like more than 90%, well more than 90% of all applications made to the FISA court were approved, and that is true. But it's also true and fair to point out that there are numbers of instances in which the FISA court approved applications only with some amendments to the minimization procedures. So the statute defines what minimization procedures are, and as you can see from the definition in the statute, they're all designed at trying to limit the circumstances under which any identifying information of a U.S. person will get out to the government. And effectively, and we'll talk a little more about this in class, the bulk metadata procedures that the government did get approved by the FISA court required the information to be kept by the government and not to be looked at until the federal government showed that there was some specific terrorist-related reason to look at it, and then they were able to pull out of those records a certain number of what the minimization procedures in those orders called hops. In other words, you had the terrorist suspect, and then a communication hop to another person, and then a communication hop to another person, and they were allowed to slurp a certain amount of that and then look at it. We'll talk a little bit more about that in class when we talk about what this resulted in. Just see now statute and what the statute required. Okay, I gave you to read the In Re sealed case decision. This is a FISA Court of Review decision from 2002. And so this is an appellate level federal decision, not a circuit court, but the FISA Court of Review set up under the FISA statute. And what I wanted you to look at there is some of the background of the statute, but also this challenge to the constitutionality of the statute. And notice that this challenge is against the background of the change in the Patriot Act that sort of shrinks the probable cause requirement to simply, the probable cause and the certification requirement to simply require the government to show that it involves a foreign power or an agent of foreign power, really kind of minimizing that. And, the court has a bunch of language about the fact that there is this kind of dire need to protect the citizens in light of the 9/11 attack, and that the balance really under the Fourth Amendment is a reasonableness balance, and this particular court saying that the balance struck by Congress under the FISA statute, given the terror threats that we see after 9/11, that the balance was reasonable. So the Fourth Amendment doesn't necessarily require the criminal level of probable cause in every circumstance. And the Supreme Court's prior jurisprudence involving surveillance doesn't necessarily require the highest showing of probable cause. It simply requires some judicial oversight. And here, the FISA Court of Review found this reasonable. Now, again, we'll talk about this a little bit more in class tomorrow as well as into next week. There have been other challenges to this statute outside of this FISA Court of Review case. I gave you the Clapper case to read. The Clapper case was a challenge after a lot of this information came to light, brought by the ACLU on behalf of a variety of public interest groups. And as you can see from the opinion, the U.S. Supreme Court ultimately decided that those groups lacked standing to pursue their challenge to the statute because they couldn't show specifically how their information had been obtained. There was another challenge in a case called Clayman versus Obama, in which a district court in federal district court in the District of Columbia, in fact, found the FISA statute as amended and the bulk metadata surveillance program unconstitutional. There was an application for an emergency stay of that order to the Federal Circuit for the D.C. Circuit. The stay was granted, and in the meantime, as I'll show you in a moment, the bulk metadata collection program expired and then was curtailed by Congress. So it never has reached the U.S. Supreme Court, and it also has never reached on the merits a higher level court. So you can see this decision, the debate is kind of still out there of whether, in fact, this program really was constitutional. Okay, the last thing I want to show you for the purpose of this lecture is some information about the USA Freedom Act of 2015. And again, I haven't given you this to read yet. I'm going to give you some excerpts to read of this for next week. This statute was signed by President Obama on June 2nd, 2015. And the backdrop of this is that the Patriot Act amendments to the FISA statute that allowed the bulk metadata collection program to proceed as it did under the orders of the FISA court were set to expire. Congress had to consider whether they were going to extend those authorities or not. And as we'll talk about a little bit more in class and then some more next week, you'll see that Congress did extend some of that to some extent, but it placed some limits on the ability of the federal government to collect this bulk telephony data. And effectively what it does now is it allows orders that require the telecom carriers to retain the information. So to be held by the telecom carriers, not to be held by the government, and then allows the government to access pieces of that information under certain circumstances. Some civil liberties groups viewed this as somewhat of a victory, but many recognize that there's a lot of ambiguity here, and this relates back to one of our big themes that I think is important for us to kind of talk about and think about, which is that when we're dealing with the internet, the infrastructure is largely privately held. The information that's crossing over that infrastructure is crossing with our consent over these privately held wires. How does that and that aspect of what we might call internet governance relate to the governance of our nation and the national security of our nation? And how does all of that relate to our expectations of privacy and our First Amendment interests? Is it better for these private telecoms to hold all this data and have the government be able to come and take pieces of it? Is it better for the government to hold it under FISA-type procedures and have the government be able to take pieces of it? Is it better for no one to hold it and have the government have to make the showing of a wiretap or other kind of more traditional order? All of those things are matters of debate. So now I'm just going to show you real briefly here some information from Edward Snowden's dump of the NSA files. And there's some really interesting slides from the NSA showing some aspects of the NSA's surveillance program and how extensive it is that Snowden disclosed. And there's really no debate now, nobody would really debate that it truly was extensive. And it's fascinating, and depending on how you look at it, chilling or comforting or both. to see the extent to which the NSA was looking into the technologies and tapping into the technologies, and having this overlay of collection that it was doing, on the one hand authorized by the FISA court, and on another hand, in some circumstances, pursuant to direct presidential authority. That's very debatable. So I'm just going to flip through these really kind of quickly. We'll talk about a few of them in class. You can also find some of them online, but I just want you to kind of see the scope of the activity.